A new California Court of Appeal held that a mandatory service charge implemented by the restaurant could be considered a gratuity that may have to be distributed to employees. The case is Grady versus Merchant Exchange Productions. In this case, the plaintiff was a server. She alleged that the gratuity, the automatic service charge that was charged by the restaurant for all banquets held in its location, it was a 21% service charge, should have been distributed to all non-managerial employees because it was a gratuity. Now, this is unique because two prior cases, which I'll discuss in a minute, have held that mandatory service charges are the property of the employer, and the employer can do with those service charges with what it wants to. This is unlike tips, which are property of the employees and must be distributed to the employees. So in this case, the plaintiff was alleging this mandatory service charge should have been distributed to the employees, and brought claims, class action, alleging violation of California's unfair competition law, Business and Professions Code Section 17200, intentional interference with advantageous relations, breach of implied contract, and unjust enrichment. Now, just as a backdrop, Labor Code Sections 350 and 351 protects gratuities as the property of the employee. And these two labor code sections prohibit the employer from taking any gratuities or tips from the employee. But there has been some cases, two cases. One is Surly versus Wyndham International, and another one, Garcia versus Four Point Sheraton, LAX, that have held that mandatory service charges implemented by the restaurant or the employer are not gratuities, and the employees are not entitled to those unless the employer wants to distribute those mandatory service charge to the employees. So the court here in this case distinguished those two cases and said that those two cases couldn't be read as categorically establishing that what may be called a service charge by an employer can never be a gratuity. And I think what the court was getting at here in this case was there's some ambiguity under the term service charge. And just because a employer or the restaurant calls something a service charge doesn't mean it's not a gratuity. And the case was very early on. It was just at the pleading stages. There weren't any facts of the case set out yet. And the court said, look, the plaintiff on the face of the complaint has alleged enough to continue in this case. So what's this mean for employers, California employers, regarding service charges and gratuities? I think the main point that California employers need to take from this is that they need to be very clear on what they call a service charge versus a gratuity. And if they do charge a service charge, they need to set out to customers and the employees that the service charge is not a gratuity and that no portion of that service charge may be distributed to the employees. And if these notices are set out clearly, that's going to protect the service charge as property of the employer versus a gratuity, which is the property of the employee. So going forward, California employers should take notice of this decision and clearly spell out either on menus, receipts, or other forms to the employees and customers what the service charge actually goes to. Thanks for watching, and if you have any questions, please let us know.